Good evening, everyone, and good evening, Ramiana, and I hope you're doing well today. I welcome you all to the third day and the last and final day of this supernatural workshop. So, yesterday, man gave all this to all and all of us as well a little work to do or little reading to do. I hope you have all done that and have come prepared for today's session. Ramiana, over to you. You can kindly begin the session.
Okay, good evening, everyone. Am I audible?
Yes, ma'am.
Okay, okay, great. How are you today? Hope you're good. We are towards the end of this 3 day workshop. Hmm. Okay, so in the last 2 days, we have seen how in the lifetime of a company, there are multiple people or multiple sets of entities that have a role to play. There are founders who will set up the company, the promoters, there are directors who will manage, there are shareholders who also have some responsibility or to have some interest in the company. Today, we will continue from where we left off yesterday. Hello, Arunima. So, and then we will move on to what we have planned specific for today. So yesterday, what we discussed was we looked at the concept of separation of ownership and management, and we also understood what activities or events can a company do, and we traced it back to what the MOA says, what the AOA says, what the Companies Act says as the law, and those sector specific regulators who specify what a company can do. You remember that? Then we also looked at the doctrine of indoor management and the Turquoise rule to understand what that says. Then we saw how does Companies Act 2013 ensure that the managers are managing properly or are doing their jobs correctly. For that, we saw that it lays down specific prescriptions in chapter 11 and 12, which deals with appointment and qualification of directors and the meetings of the board of directors. Then it asks the company to set up certain committees, which again are headed by these board of directors only. Certain committees we saw. Then it mandates certain registers to be maintained, filings to be done, reportings to be done. Then it also requires the company to have its financials in place, maintenance of its accounts, proper appointment of auditors, rotation of auditors, or change in auditors, disclosure relating to the auditors. It specifies that. And lastly, it also has powers to do inquiry, to conduct investigations and do inspections in the company to check whether the company is operating properly, whether something seems off. All of this are mechanisms of used by Companies Act 2013 to ensure that this concept of separation of ownership and management can continue and the managers do their job properly. So you all understood this so far. This we dealt with yesterday. Do you have any questions from this? Or did you understand it? Okay. So we also saw what role do shareholders play. We saw that they have this important role of exercising their vote, but that vote does not have to be academic or a mechanical exercise. It has to be an informed vote. So we looked at the practical aspect of interest of shareholders, how certain developed corporate governance jurisdictions have concept of shareholders activism, how SEBI came up with proxy advisors and a regulation for proxy advisory firms and research analysts. We looked at this aspect also. Now today we'll continue from where we left off and we'll see how do the board of directors manage. Now, the mechanism for the board of directors to manage is given by a plethora of sections. So, what I would like you to do, and that is why I asked you to read these sections and come, is that we will look at these sections and we will again touch on that concept of separation of ownership and management. See, understand this: whenever we read something in theory, we will forget that theory, or we will forget the implication of that theory unless we can imagine in practice what does it look like. I'll give you an example. When you will be talking to your juniors, or you will be talking to people who are non-law about anything that you have learned, imagine if suppose there is a new development in the corporate sector or in that area in which you're talking about, but you could not link it to the theory that you have learned, and you could not understand that how that particular theory has now taken a turn or it is getting impacted. These only get when we link concepts with practice is essential for us as lawyers to have that edge in what we speak, in what we do, and in how we think. So these theories that we learn, these concepts that we understand, we should, whenever we read provisions, see if it is just a mere provision which is or whether it is serving a larger purpose connecting to some fundamental theory. More often than not, it will have that purpose, it will connect to some theory. So starting with the first one, that is the eligibility of directors. I hope again you have the Companies Act in front of you. If not, then please take 2 minutes, open the Companies Act, the latest version, and scroll down to chapter 11 and look at section 164. So this particular section talks about disqualification for appointment of director. Now, understand it this way: if a company is doing well, or if a company is giving the perception of it doing well, then people will definitely trace it back to those who are managing it, correct? Like if our country is doing well, people will definitely connect it to the politics, the policy of our country, and the competence of the governance of our country. So if a company is doing well, the directors themselves have to be people who are eligible and who are qualified people to conduct business or conduct or manage the company. That is why this particular section 164 is not just important in Companies Act, but you will notice that every sector specific regulator, for banks it is the Banking Regulation Act, for insurance it is the Insurance Act. Each of these sector specific laws will also mention similar qualifications, similar eligibility for the managers or the directors or those managerial people, because it is very important that these people should be well qualified to handle a company and its business. So for example, see in section 164 it says the director should not be a person of unsound mind, he should not be an undischarged insolvent, he should not be a person who is convicted of any of those specified offenses, he should not be a person convicted for engaging in a related party transaction. You can see that similar provisions are there in the constitution also with respect to our ministers. How do we say that they're eligible to hold that position or that office? You will find similar provisions there. So it's very important that when we as lawyers do these checks, we should know, okay, are these directors eligible? Have they declared their eligibility with the respective e-form filings? And then they should have gotten their DIN number, the DIN number. Okay. So first is how does the board of directors do the management? First is the Companies Act sets out eligibility for directors. This is given in section 164. You can note this if you want. I'll just quickly put it in the chat box. That is one. Next is the capacity of directors. This is very interesting because imagine if I am somebody who is working for you, you and I have a professional relationship, you have hired me for gain, you have hired me for some work. then your interest in me should only be to the extent of how I'm performing that work and whether the results you expected out of me is done. You will not check whether that day I was interested to do it, whether I had a good intention. Your interest in me should just be whether I got the work done, whether I'm doing it in a proper manner, and whether I'm fetching you the results for which you hired me. But for directors, because of this concept of separation of ownership and management, because they are not people who are also owning the company, there is an aspect of capacity of directors. And by capacity, I mean, please stop me if I'm going too fast or if you don't understand what I'm saying. By capacity, I mean fiduciary. Fiduciary is the word we use in the context of trust and goodwill, goodness, or good faith. So, if you scroll down to section 166, subsection 2, it specifies that a director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interest of the company, its employees, shareholders, community, and environment. That means that a director of a company is not just involved or engaged in the company in terms of what he does, but also how he is doing it. The Companies Act is going to the extent of specifying that the intentions of the director have to be good, that the faith of the director towards the company has to be positive, and that what he does has to be in the capacity of a trustworthy person. So through this we can identify how if all of us are partners in a partnership firm, nobody would tell us that we need to be acting in good faith, because it is a given that we are owners. We will only do that which is best for our firm. We are all partners in this, so we all want to fetch money out of it, we all want profits out of it. So nobody will specify that, hey, have good intentions, be in good faith. But when there is a separation of ownership and management, the owners will require the support and the trust of the legal mechanism to prescribe to the managers that, hey, prescribe it under law and make it specific that they should be people who carry on work in good faith. They should carry it on with a feeling and capacity of trust. That is why when you read section 166, connect it back to what purpose is it serving. It's because of this concept of separation of ownership and management. So the director will act in good faith, promote the objects of the company for the benefits of its members as a whole and in the best interest of the company. So well put, so well arranged, the sequence of words. And employees, shareholders, community, and protection of environment. So you can note, if you're noting it down, you can put an asterisk next to it and say this is indicative of separation of ownership and management. Did I mention in the chat box? Yes, capacity. Number 3 is the board meetings where board resolutions are passed. So of course, whenever the board of directors want to make any decision on what next to be done with the company, we seem to have done well in this quarter, we can use this money to set up a new plant, or we can retain this money, put it back into the business, or shall we declare dividend now. So these kind of decisions, of course, they will have to take by meeting and then by voting and then having board resolutions. Again, these board resolutions will be documented, and no company will allow any person to be privy to these board resolutions unless you're a qualified advocate, you are under a mandate. Then you go to the company's office, you sit 2 days, 3 days, and look at these huge fat minutes of the meetings where you can identify every single board resolution, what date, what decision was taken, who all were present, each of these things. So the third is board meetings where board resolutions are passed. I will put this in the chat box. Are you following what I'm saying? Are you getting how we're proceeding? Okay.
Mhm.
So board meetings where board resolutions are passed, this you can identify from chapter 12 onwards, that is section 173. It will also specify what is the quorum, like for each meeting, how many directors should be there minimum. So the Companies Act says 1/3 of the entire board or at least 2 directors, whichever is larger. So of course, generally it will be 1/3. So 1/3 of the entire board must be present, otherwise it's not a validly held meeting. And then it also specifies that to hold such a meeting, all the directors must get at least 7 days of notice, and they should be informed that, okay, we're holding meeting within 7 days, and then you convene the meeting, call for a meeting. If it's urgent, you can do a shorter notice. So look at chapter 12 for this. That's the third point. The fourth is the powers of the board. What all powers does the board of directors have in their capacity of managers of the company? How will they run the company's affairs and its daily routine business? So section 179 helps us in this. Just put it in the chat box. Section 179, if you look at it, it says the board of directors, this is again interesting. The board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. That means, remember yesterday I had posed a question that in this concept of separation of ownership and management, how do you draw the line? How do you know what can the board of directors do? What can the managers do? And when are they stepping into the capacity of owners now? Like, for example, if tomorrow the board of directors decide that all 15 of us, from tomorrow onwards, all the profits of the company, we're going to first just share it amongst ourselves for a couple of months, and then we will continue with what the company does. Or for some time, let us just have very inflated salaries or commissions. So these kind of decisions is obviously going to hamper the interest of the owners. So where do you draw the line between, how do you separate ownership and management? So you can see that this section 179 helps us because it says the board of directors shall be entitled to exercise all such powers and to do all such acts and things which the company is authorized to do and exercise and do. That means whatever your MOA and specifically whatever your AOA allows the company to do, the board of directors can also do. So if a company can acquire property, if a company can open a new plant, if a company can borrow money, then the board of directors can also do each of this. If a company can diversify, if a company can change its name, then the board of directors can do each of this. But except for those things which need to be done at a general meeting. That means the board of directors in their meeting can decide and talk about all things, every agenda, every specific matter, which a company can also decide. So every object, every event, activity, matter which the company can do, the board of directors can do. So the company wants to diversify, company can diversify, company wants to open a new branch, new plant, invest in some new machinery, or borrow huge amounts of loans, give grant loans to someone else. It wants to act as a trustee for some other company. Each of these things the board of directors can also do. But there will be certain matters which, after having decided by the board of directors, they need to also get it ratified or need to also get it run through by the shareholders in their general meeting. So the difference in ownership and management is all the first hand decisions, all the first level of discussions, deliberations, matters, events, everything that a company can possibly do, you can stretch and squeeze it as much as you can think of. Everything the board of directors can do, they can exercise that power. But a portion of that might also require the involvement of shareholders, where they will also look at those agenda and they might approve it, they might not agree for it, but you have to run it by them. So that explains the extent to which the board of directors can exercise their power. So section 179 subsection 3 specifies they can borrow money, they can issue securities, they can diversify the business, they can even approve any merger or amalgamation, and they can even acquire or take over a company. So you can put a star mark in section 179. I really hope you've read this and come, because that would make it easier for you to understand the structure of our what we are discussing and the flow. So section 179 I'm talking about. Subsection 3 specifically categorically lays down what all powers does the board have. Can borrow money, they can issue securities, can diversify business, even they can approve any merger or amalgamation or acquire or take over a company. Clear? But again, when you read section 179 subsection 3, remember that 179 first, the first sentence in 179 talks about the fiduciary capacity. So that makes it interesting. It specifies that you can do these A, B, C, D, E, F things. But remember, you are a board of director person. You are one of the directors on the board. You have to be in fiduciary capacity. So whether you borrow money or not, whether you issue securities, whether you do a merger, you plan to do a merger, remember you are acting as a fiduciary and you will do it in the larger interest of the company as a whole. With that perspective, you read the specific powers laid down. Next is, so we saw these 4 points. The next is, put it in the chat box, restrictions on the powers of the board. So the Companies Act also says that certain activities and certain actions are restricted to the board from doing. Restricted in what sense? That they will require special resolution for each of these. That means they will require the shareholders to come and meet, and in the meeting of the shareholders a special resolution, that means you need 3/4 majority to pass that particular agenda item, and then the board of directors can take it forward. What are these? It gives an illustrative list. It says if the board of directors want to sell a whole or a part of an undertaking is any investment made by the company which is 20% of its net worth. Don't go into the technicalities of it, but the section specifies that a whole or a part of the undertaking, if the board of directors want to sell it, then they are restricted from doing this unless they have shareholders special resolution. Second, if they are borrowing money beyond a specified threshold, again they will have to take shareholders resolution. And third, if they are extending the time of any debt due to any director, if the company has given a specific director some money as a loan or a debt, and they're extending the time of repayment of that loan, then such agenda item will also require shareholders special resolution. So you can look at this section. This is 180. So this is section 180, restrictions on the powers of the board. Very important. Generally also asked in exams, I think. Next, next we come to KMPs. Remember I said when we talk about managers, it's not just the board of directors, it is also the key managerial personnel. Key managerial personnel, as per the Companies Act, is your managing director or your CEO. That's the first person, managing director or CEO. Second is the CFO, the chief financial officer. And the third is the company secretary. For all purposes, as far as the MCA website and the registrar is concerned, the ROC is concerned, the registrar of companies, he will interact with this company secretary for all filings, all reporting, all timely compliance. He will catch this company secretary. For each company, there will be a company secretary who is a KMP. So these KMPs are key managerial persons, and the Companies Act talks about them in chapter 12. So your CEO, CFO, and company secretary, these are the KMPs. And also, what time is it now? 6:30, right? Fine. So section 205, this is just an FII. So section 205 talks about what are the functions of the company secretary. Remember when we were looking at the when we pulled out the master data of Tata Sons from the MCA website, and the email ID of the company had the name of the company secretary, and I told you that for all correspondences and for all for all discussions or any if they want to clarify any matters, they will catch the company secretary. Not just this, whenever a company raises funds through the public, and it will have these prospectus or whatever, let's not get into what it's called, it will have these documents filed which are released in the public. There also the phone number and the email ID given from the company is that of the company secretary. So the role of the company secretary is highly paying, well paid job, but also very strenuous and taxing, because so much work. You are responsible for all correspondences, all filings and registrations of the company. Now notice that in section 205, the Companies Act says that the company secretary, one of the functions of the company secretary is that he will comply with secretarial standards. Secretarial standards. So, the activity that we are going to be doing is that you're going to find out what are secretarial standards and where are they available. Okay. Once you find this out, then I will tell you some tips or some helpful things about it. So not now, maybe at 7 when we take a break. I'll just note it here. What are secretarial standards? Okay. So we will circle back to this. Also another, so now this is done. This is how the Companies Act ensures that the managers do what they do and they do it properly. That is by eligibility, by having board meetings, capacity, powers of the board, and restrictions. Other than that, of course, your objects clause will help you in what topic, in what area is the company engaged, and relating to that only the board of directors will take all the decisions. Another thing to note with respect to the shareholders is that the Companies Act also goes one step more beyond voting and exercising their vote. The Companies Act also ensures that if any shareholders feel oppressed, or if any shareholders feel that there is any mismanagement happening in the company, then a separate chapter is dedicated in the Companies Act just for prevention of oppression and mismanagement. And there, these shareholders can come before the adjudicating authority and file their petitions. So this is chapter 16. You can skim through it later if you want. But the point I'm making is that the Companies Act ensures that this balance of separation of ownership and management is well maintained by legal mechanism and by specific prescription to both the managers and the owners. Okay, especially because these promoters who will be the founders of the company, they will generally be the ones who would have started the company, and then their sons would take over. They will always feel, like I told you last time also, remember that in practice these the directors or the promoters who are not supposed to be part of the meetings, they exercise a lot of influence. So if I am a shareholder of a company and I know that this X person is the founder, he's the promoter, all the directors are going to listen to what he has idea about the company. The directors are going to ensure that it comes through. But when I have an idea, nobody's listening to me. So if I at any point feel oppressed, then I have these legal mechanisms in place. So the concept of promoter shareholder being an influential person is a very hugely debated topic in our corporate law, because we are still developing our corporate governance. But this is changing slowly. Like I told you last time, the concept of family owned businesses becoming company is changing slowly. The promoter shareholding is reducing and different public shareholding is increasing, which is good for our corporate governance and our corporate sector. Okay. And also the shareholders need to be informed. There have to be annual returns that are filed. The shareholders will get access to it. Shareholders are allowed inspections of the registers in the company's registered office, and of course they exercise powers during AGM and EGM. So that's how the shareholders play a role. Now, having completed this, any questions so far, by the way? Are you following what I'm saying? Okay. Others, are you listening? Okay. Now, after having discussed what the shareholders do, what the owners do, I want to discuss just two more things and then we'll move on to the next portion. In the lifetime of a company, the board of directors will, of course, take many decisions pertaining to the company: when to borrow more money, when to apply for a new license, or whether they want to open a new branch. But there are two very major events which I think is worthy of discussion in our workshop. The first is when the company decides to get listed, and the second is when a company decides to undergo any merger, amalgamation, acquisition, things like that. So, since these are quite complex, I'm sure in your universities a separate elective subject is dedicated to mergers and acquisition, and a separate elective subject is dedicated to securities law. But what I want to bring to this workshop is the practical side of it, which is generally known and probably not taught in classes. So these two events, one is getting listed and the second is merger and amalgamation. I'm just telling you things to know, basic things. So first you tell me, do you understand what it means when I say it's a big event that a company gets listed? What does it mean getting listed? Can one of you answer this for me? What does getting listed mean?
The company has been selected for among some of the companies.
1 second, you're not audible. Is it my? Can you be a little louder?
I think as the meaning of listed is the company has been selected among some of the companies.
Selected to do what?
Um, just like
You're saying recognized?
yes,
Okay. A very, what do I say? Like a very honest answer, very simply thought. I like how you're thinking, Anshika. But once you probably understand companies law and securities law, you will be much more informed. So getting listed is actually nothing to do with getting recognition or getting selected by any regulatory authority. But very fair attempt. I appreciate that. Does anybody else want to take a shot? No? Included and traded on a given stock. What does that mean, to be included and traded? Because if we put it this way, then others won't understand, no? Can you just elaborate a little more? Be included and traded on a given stock. We have benefit of sir's presence with us. Rajneesh, so would you like to also pitch in and educate our dear students on what getting listed is?
Thank you,
If you
ma'am,
would
for
like.
this opportunity. Thank you, ma'am. Should I explain what is listed company?
Yes, so
Or
you
what?
can just simply, if you want, you can just tell them what does getting listed mean.
Okay, dear friends, as we are knowing that there are two types of companies. One is called private company, another is called public companies. First of all, as per section 268, 2 class 68 of the Companies Act, private companies can't invite public directly for their shares and the debentures, or that is called securities. So to trade its securities under the Companies Act, it required that it should be listed. A listed company means a company which has listed its any of the security on the stock exchange, recognized stock exchanges. There are 25, about 25 stock exchanges, but at least two are very important, that is NSC and BSC. And then if any company, definitely it is a public company, if it will list its any of its a security like share or debenture, then it will be called a listed company. Prior to 2020 amendment, even the private companies were used to list their debenture only, because they were not supposed to list their securities, means share. But even after the amendment of 2020, they have been prohibited. So nowadays, after 2020, we can say that only a public company that can list its security, and that will be called listed company. But even though I think if any company had listed its equity security, then it will be listed, and then whether it is listed its debentures or other shares, it is immaterial. But if it will list its not listed its equity security, but it listed only its suppose debenture, non-convertible debenture, then it can be called again any listed company. Okay, so first of all, it have to list its security. Its security means it's a equity security, equity share. Okay, one thing. Second thing is that if it is not listed, it's equity security, but it listed its any debenture that was issued on the basis of private placement, then again it will be not called as a listed company. Similarly, if any company has not listed its equity security, any of its security in our country, but it listed its security in a foreign jurisdiction, then again it will be not called as a listed company. Okay, so listed company means a company authorized to trade its security on the platform that is called a stock exchange. Okay, ma'am, thank you.
Thank you so much, sir. So wonderfully explained. I highly doubt, sir, why are you even part of our workshop? There is nothing I can offer to you that might be a takeaway.
ओके मैम, बहुत अच्छा लग रहा है मैम, बहुत अच्छा आप एक्सप्लेन के पूरा कंपनी ला को आपने 3 दिन में समराइज किया है. इट्स अ वंडरफुल जॉब एक्चुअली.
Oh, thank you, sir. Thank you so much. Very honored. So, if you heard what sir has said, he's explained what a listed what does getting listed mean. So just to put it in brief again, whenever any company taps onto the primary market, that company has gotten listed. Listed means right now the company has multiple people. We remember we discussed the MOA will have the subscribers clause, and it will show each subscriber how many shares he has put, what has he contributed. So he would have taken a share, he would have contributed some money to the company. Now if a company has, as on today, say 15 subscribers, 15 members, 15 shareholders, and each of them have given 1 lakh, and they have say 1 share of 1 lakh each. So that particular company has a specific share capital, specific number of members, and each of them hold that many number of shares. If this company decides that okay, now I've become like a large enough company, I need to continue my actions and my business. For that I need public fundraising, I need money from the public, I need to raise money from the public. So it will tap on to the primary market, and it will ask SEBI's permission. SEBI is that Securities and Exchange Board, and it'll have to file, or it will get itself listed on the stock exchange once SEBI allows it. Okay, fine. You're a big enough company. Your directors seem to be doing a good job. Your objects are fine. Your filings and reporting, no problem. There is no some criminal charges against any of the directors. Everything seems to be happening lawfully and well. It will do all of its checks, and then that particular company can start now, get itself touch the primary market, do an IPO, an initial public offer, through which, see, we saw news, right? This Paytm, Zomato, these fintech companies, they couldn't do well, their IPOs didn't do well, they had to tank a little bit. So these companies, they do public fundraising where the general public will give money to the company, and instead the general public will get equity shares, the equity shares of the company. Now they are also part of the company's ownership, and the company has now gone public, and the company is now listed on stock exchange. Once it does this, then the general public can just start their trading. They will start trading on the stock exchange. And most interesting, that is what you should remember now that we've discussed this, is yesterday we discussed register of members, you remember. So each of these people will now get included in that register of members. That is how we will check as on today who all are the members of the company. So getting listed is a huge event that the company undergoes. Yes, Harish? You have a question? Are you typing it? You can just unmute yourself and ask. So getting listed is this huge event that a company can choose to undergo. It can choose to remain unlisted public company, or it can choose to remain private also. Yes, Harish? Okay. So that is one event. The second event is mergers and acquisitions or amalgamation, where a company can choose to merge with another entity, or it can choose to acquire another entity, or it may get acquired. So this is also a huge event. So in terms of company law, these are all kind of complex. I'm not going to go into section by section, but like I said, there are certain things you need to know. First is that companies will definitely, I think somebody asked me a question also, that ma'am, will AOA and MOA, both of them get altered in a merger? 100% both AOA and MOA will get altered. Because see, after the merger or after the listing, the company might have a change in its name comes under MOA, it will have to change, or definitely the share capital will change, again the MOA is going to change. And once it's done with the merger, if it is a bigger company, now the roles of the directors, the voting, or the exercise of the shares, or who will take what decisions, all of this will again change. So AOA will also get altered. So the first thing is, yes, the MOA and AOA will get altered, which automatically means that the shareholders resolution is important. You will have to first tell your shareholders that, hey, we as a company, we are deciding that we will do a merger, or we are going to do an acquisition, or we're going to we're thinking of becoming a listed company. So the shareholders have to be on board. That's number one. I'm just telling you brief pointers on what you need to know at this elementary level. Second, there are a lot of approvals in place, lot of approvals. And I will give you an interesting anecdote for this. So when I was an intern at one of these law firms, and that particular law firm was trying to do an initial due diligence for an IPO. So what happened was, this particular company, which was a client of the law firm, was involved in selling spare parts of automobiles. They would sell these all the spare parts of automobiles, cars and all. And they had these deals, they had these big showrooms where they would sell Maruti cars, they would sell Honda cars, all these big brands. They would sell the cars, and they would also do sale of spare parts. And in one of these agreement, like they had an agreement with Maruti, they had an agreement with Honda. In one of these agreement, it was specifically mentioned that if tomorrow you decide to become a listed company, you must ask my permission. That means our agreement stands only as long as you will fulfill these conditions. Tomorrow when you do an IPO, you must, or choose to become a listed company, you must take my permission. So I was an intern at this law firm, and I was given a big set of documents, and I was asked to check these kind of agreements with this kind of a it's called OEM. Let's not get into the technicalities, but these kind of suppliers, let's say these kind of big brands, they had agreements with these brands. Look at those agreements and see whether there are such clauses which say you need our permission. Then they also gave me these big set of documents with banks. This particular company, which was our client, which was selling automobile spare parts and also the cars, that company had account with multiple banks, and it had taken huge amount of loans from several government banks and non-government banks also. And they gave me those agreements, and they said, look at these loan documents and see where it says that the company needs permission of that particular bank before doing IPO, or company needs permission of the bank before increasing its shareholding, or company needs permission of the bank before doing a merger. If there is any such what my senior told me. So lot of approvals are required to be in place before a company can do such major events like listing or merger. And these kind of clauses where the supplier or the creditor or this kind of manufacturer brands will specify to the company that whenever you do such big events, you either inform me, so that means they will say prior intimation is needed. Then we will prepare a document saying we are thinking of doing a listing, we are hereby intimating you that we are going ahead with the listing. Or that agreement will say not just intimation, you need to take my permission, you need to take my prior written consent or prior written approval. So these kind of document vetting is again our job. You will do it, I will do it. We as corporate lawyers, we will engage in this kind of diligence and document vetting. Extremely essential. In fact, it is so essential that one of the suppliers, he refused to give permission for the listing. He said, I don't want this company to list. And that particular supplier was so important for the company that maximum profit they were getting from selling those cars only. So they could not go ahead with the IPO, and the IPO had to stop. All the work that we were doing from day one stopped because that one brand did not sign or did not give consent to doing the IPO. And their agreement categorically said, if you do IPO, you need my consent. So the second thing you need to do is that there are a lot of approvals in place. The first thing, when any company decides to do any big event, it will come to one of us, it will come to us corporate lawyers, it will come to the law firms, and the first thing they will ask us to do is quickly check these third party agreements, whether there is any clause stopping us from doing this. And then we will quickly reach out those specific people and try and convince them, try and ask their permission. Clear? Interesting, right? That's the second thing. So sectoral regulators will require permission. Even like certain the insurance regulator, IRDAI, or the banking regulator, RBI, will also have similar clauses in when they are granting license, that okay, I'm giving you license to operate as a bank, but tomorrow when you do a merger, tomorrow when you do shareholding pattern is changing, or tomorrow when you're appointing any new significant director, you must take my permission. Or you're doing IPO, you must take my permission. So these sectoral regulators, creditors, suppliers, banks have these kind of clauses. Next is another interesting thing when the company does these big events is that each company will have its own counsel. So the law firm where I was working, we were generally our clients were companies who would want to do IPOs, and or let me put it this way, if there is a merger happening between two companies, then each company will have its own advocate, each company will have its own law firm, and both the law firms will interact with each other. This particular law firm will check all the details about this company, this particular law firm will check all details about this company. They will see all due diligence filings, are they doing properly, directors, are they doing their job properly, reporting is done, last 5 years anything fishy has happened, is this a risky business, and then finally they will give their opinion on yes, ready to do the merger, good enough company, just change these 1 2 3 things, like that they will negotiate it there onwards. So each company will have its own counsel. And then the fourth thing you need to know, should I put this in the chat box? See if it's helpful, I'll put it.
Yes, ma'am.
What I told you was each party has a counsel. That means each company interested will have its own advocate. And then the fourth thing you need to know is that these kind of big decisions, when a company decides to get listed and when a company decides to do a merger, the company has to justify to the MCA and the other regulators as to what will happen to the shares, what will happen to the employees, what will be the position of the directors, and if there are shareholders who are not agreeing to this kind of big event, but he's a minor shareholder, so the company still went with the event, then there has to be an exit option for these shareholders. The company has to provide for an option for these shareholders to exit the company because they were not in favor of these big events that the company went through with. Then the fifth thing you need to know is that these kind of big events, especially listing, it's not true for merger, but for listing it is true, that they are timeline specific. So I remember when me and some of my other juniors, when we got when we were employees of these law firm, and I joined the capital markets team, and my other friend joined the mergers and acquisition team. And her senior told us that tomorrow, if you make a mistake, then the company which is our client, which is paying us all the money, with them we have an agreement that we might have to return that entire money, or they will no more hold us as their counsel for their next transaction. And then I went to my senior and I asked that if I tomorrow make a mistake, do I also have the same liability, that whatever money they gave us for this entire transaction, they can take it back and they will no longer hire us? So my senior told us, no, you are in the capital markets team, which means you are in charge of these IPOs and listing. If you make a mistake tomorrow, then SEBI, because we have a regulator for listing, the capital markets regulator, can hold us accountable as lawyers, and we have a deeper responsibility. We have a more risky liability in terms of our, we can be fined, we can be blacklisted by the regulator. The regulator can pinpoint which is the advocate responsible for this particular listing. It's done in a fraudulent way, it's not done in a proper manner, there seems to be some fishy business happening. So our responsibility is even more deeper and more serious when it comes to this regulator invested kind of a major event like listing. So it's timeline specific. The SEBI will specifically say, okay, I'm giving you this much days within which you must finish your listing process. So it's timeline specific. Fast, you have to work faster. You can't extend the deadlines. And the last thing you need to know is that there is a lot of liability of due diligence. In the end, as us as counsels, you and I, when we will finish the entire transaction, we read everything we needed to know about the company. We asked them all the right questions. We looked at all their papers, and then we will take it on our own name, the law firm's name, and we will give them a certificate of due diligence, where we will say, through the course of these 3 months, from this date till this date, I, as your counsel, have looked at ABCD records. I have done in-person due diligence inside your company's office on this date. I have looked at these reportings, these filings, and this is my final certificate of due diligence, that everything seems to be in place. The AOA MOA is as per Companies Act. That certificate I will give, or we will give, in the name of the law firm. These are the 6 things I just thought that you should know generally, which is not introduced to students in classes. So it is 6:58 now. So we will break. Sakshi, can we take a break now?
Yes.
So we'll break for 10 minutes, and you tell me that answer to that question I asked. What are secretarial standards and where is it available? Okay. Just you can check it however you want. Okay, see you at 7:10.
Yes, ma'am. I request all of you to please join back by 7:10 p.m. so that we can continue the session.